To follow the noble Baroness Lady Hoey and to speak in support of this amendment, which also is in my name, because this issue goes to the heart of the political crisis that currently afflicts Northern Ireland. And we are debating today a bill which, in a way, I suppose, ironically, arises out of the previous crisis in Northern Ireland. And we've had a series of such bills over the years. And indeed, noble lords on the Labour front bench will recall when they were in office, their party was in office, they too brought from time to time various bills concerning Northern Ireland and the operation of not just the Assembly and the institutions, but also sought to bring legislation on things like legacy and other issues which we're still grappling with today, which shows that in terms of Northern Ireland, many of the issues are still to be resolved. This is a work in progress, and many people who felt that once we had the Belfast Agreement in 1998, or indeed subsequent agreements, that everything was fine, then they have been disillusioned of that, of course, by events. And one of the problems has been that instead of adhering to agreements that have been entered into, there have been efforts to undermine the principle of consent, which is at the heart of the Belfast Agreement as amended by the St Andrews Agreement. And this is what we're dealing with when it comes to this particular amendment. In terms of timing, I totally accept, as Baroness Hoey has said, that the Minister, the noble Lord, the Minister, has had very little time to consider this matter. Indeed, members of the other noble lords as well. So we clearly understand that, and this is a matter, no doubt, that we will have to consider over the coming days and at a later stage of the bill again, no doubt. But I would emphasise that this is a matter of urgency because, as things stand at the moment, the protocol, given its danger to the Union, and Baroness Hoey has again alluded to the court action which is currently underway, not just the finding in the High Court, but also some of the government's own lawyers and their submissions, very troubling and worrying to Unionists in Northern Ireland, where they have argued that the sections of the Act of Union, particularly Section 6, are effectively suspended by the Withdrawal Act, which is an incredible position for a Conservative and Unionist government to find itself in the courts arguing for. It really is quite staggering. So I think that whether it's today or another day, but certainly it needs to be soon, that this issue of the protocol is addressed. And at the heart of it is the issue of democratic consent. And earlier in the debate on other clauses, my lords, we have discussed the importance of the principle of consent and the assertion of its primacy. And we have discussed issues concerning returning things as to the way they were in the 1998 agreement. What was at the heart of the 1990 agreement but the principle of consent, and the idea that there should be cross-community support in the Assembly for every key decision. As Baroness Hoey alluded to in the Strand One 5D of the Belfast Agreement, that's explicitly referred to, so that we have a situation, for all the reasons we know, that every key decision, every major decision made in the Northern Ireland Assembly is either a cross-community vote or susceptible of being turned into a cross-community vote. And that was agreed not by us. It was agreed by those parties who put their hands to the Belfast Agreement. I mean, in the amendments that were made in St Andrews, we made some improvements to the overall structure, but that was the fundamental agreement that was made. There's only one key vote, one important decision, which is probably the most important decision of all, which cannot now be a cross-community vote. And that is the vote in 2024 on whether the Northern Ireland Protocol should continue to apply. In other words, that the EU laws on manufactured goods, agri-food, VAT, state aid, etc., etc., etc. Those matters covered by Articles 5 to 10 of the Northern Ireland Protocol. All those matters, whether those should continue to apply in Northern Ireland or not, to the subjects, to the people of Northern Ireland, and those laws made without any final decision being susceptible of being made by anyone in Northern Ireland in the Assembly or anyone at Westminster. They're made in Brussels. Not necessarily, certainly, not in the interests of Northern Ireland. They will be made necessarily in the interests of those who make them. It's there. I mean, I don't object to that. That's perfectly understandable. But the fact that we're then subjected to them, even if they disadvantage us, is an outrageous proposition in the 21st century for a modern democracy, and certainly one that would not be tolerated in Scotland, Wales, or any part of England for a second. Certainly not taking back control. And the decision, of course, in 2024, which is offensive in its own right, because it should be a decision made now. It should have been made prior to this being enforced and coming into force. But in 2024, this decision is then to be made by a majority vote. So it cannot be turned into a cross-community vote. It's not a cross-community vote. And that was done in the Protocol on Ireland, Northern Ireland Democratic Consent Process EU Exit Regulations of 2020. One of the most significant changes to the structure of the Assembly and the principle of consent made in subordinate legislation, in regulations, which I've just described, not by primary legislation, not on an Act of Parliament, but unilaterally by the government, here in Parliament, making a fundamental change to the way in which the Northern Ireland Assembly takes decisions, and again, no vote in the Northern Ireland Assembly in such a matter, but one which was made here unilaterally. And, my Lords, the significance of that should not be underestimated, because the government's argument was that this is not a devolved matter. The reality, of course, is that if it's not a devolved matter, then there shouldn't be a vote in the Northern Ireland Assembly at all. If it's not a devolved matter, it's a vote for Parliament. By giving the vote to the Assembly, they then decided to change the voting mechanism in order to ensure that one outcome would be agreed. And, my Lords, that, on top of everything else regarding the protocol, is something which has rightly exercised unionists of all parties and backgrounds and descriptions in Northern Ireland. So what these amendments seek to do, my Lords, is to restore, as we've heard earlier in some of the arguments that have been put forward in relation to other amendments, restore what the original agreement said. Restore what the 1990 Act said, 1998 Northern Ireland Act said. Restore the principle of consent on a cross-community basis for all key decisions. And would actually, if done in a timely way, go some way to alleviating the current crisis and perhaps avoiding what's coming down the road. Because as I said in the second reading debate, it is simply unsustainable for people to expect that the institutions will just operate as normal, whilst the East-West relationship has been trashed, and indeed which is the Strand 3 part of the agreement, as well as the Strand One through the changes that were made to the consent principle and the mechanism in terms of agreement. So I really would urge the noble Lord, the Minister. I understand the difficulties today with the late notice in terms of being able to examine this in detail, but to take on board the heartfelt views and the real concerns, matters of principle, that are at the heart of these amendments.